Good morning and welcome to episode 65 of our Case of the Week series, published in cooperation and partnership with 𝐒.𝐃.𝐍. My name is Kelly Twigger. I am the CEO and founder of 𝐒Discovery Assistant and the principal at ESI Attorneys. Thanks so much for joining me today. Each week, as you know, on our Case of the Week series, we choose a decision from our eDiscovery database and really try to pick things that highlight key issues for litigators and folks involved in the eDiscovery process, and talk about the practical implications of that decision and what it really brings out as key points for us to consider in our everyday practice. As always, you'll find a link to the decision at a public link from eDiscovery Assistant in the comments section of whatever platform you're viewing us on, whether that's Facebook, LinkedIn, Twitter, or YouTube. Took me a second there. Also today, you're going to see a link to Doug Austin's post on this same case on eDiscovery today. And as we go through our discussion, we'll add a link to our write-up series on ESI protocols from the eDiscovery Assistant blog that will also be helpful as you're thinking about the issues raised in today's decision. Okay, so let's kind of dive in. What is the case that we're looking at today? Today's case is from Rain Group LLC versus Rain Capital LLC. And you can tell from the name already that we've got a trademark infringement, an unfair competition case based on the defendant's use of the name Rain Capital. Rain Group, which is the plaintiff, is spelled R-A-I-N-E. Rain Capital, which is the defendant, is spelled R-E-I-G-N. This is a decision from just a couple of months ago, February 22nd, 2022. This is a decision authored by Magistrate Judge Katharine Parker out of the Southern District of New York. And if you're a regular on our Case of the Week series, you know that we routinely cover Judge Parker's decisions because she is an extremely thoughtful jurist on these issues. Judge Parker has 53 separate written decisions on eDiscovery in the eDiscovery Assistant database. She's quite prolific and well-educated on these issues, and it's always a pleasure to cover her decisions. You'll recall that Judge Parker was the author of the 𝐑𝐚 cases, which have been discussed in great detail over the last year. We covered them at the UF conference. That was the case that discussed whether or not hyperlinks in an email were considered attachments for the purpose of production, really in the context of Gmail and Teams data, which now use links to documents instead of attaching the physical document to the email. So as always, it's again, really great to see Judge Parker's analysis. And I'm going to share with you a lot of her language from this decision today, because I think it's really important as it pertains to what is appropriate for inclusion in an ESI protocol. All right, so what are the facts of our case? This, as I mentioned, is a case on trademark infringement and unfair competition based on the defendant's use of the name Rain Capital. The plaintiff here is a 100-person bank, so 100 employees at the plaintiff. The defendant is a 2-person real estate development firm, and again, plaintiff suing the defendant for infringement based on the name of the defendant's firm. The parties are before the court on a dispute related to language in the ESI protocol that covers really 3 different issues. 1 is the language regarding the parties' search obligations in general. 2 is regarding certain specific search terms and whether or not modifiers should be applied to those terms. And the 3rd is what custodians are to be searched for each party. And before we kind of dive a little bit further into the facts, as we're talking about this, I want you to really think about whether the kind of language that's proposed here is what you would want to include in your protocol to begin with. As you can see, and this is where we can add the link to our ESI protocol series from the eDiscovery Assistant blog. That series breaks down each of the elements that you'll want to include in your ESI protocol and all of the individual issues on each of those elements. One of those elements is search terms. Rarely do we discuss how many or agree on how many custodians will be searched at the time, although it is often the point that sometimes we'll talk about the process of parties agreeing to exchange a list of custodians to be searched. but not necessarily agreeing upon a number. And the reason for that is that the discovery process is continuously iterative. And when you agree to details like specific search terms or specific modifiers or the process for searching in terms of actual sources of ESI that you're going to search, when you get into that level of detail, you're really limiting what the party's obligations are. And so we're going to see how the court addresses that. And it's really a great decision from Judge Parker on that issue. So essentially the court, this was a dispute, I think, that had been ongoing for a while, and the court ordered the parties to either finalize the protocol by February 9th or submit the dispute for the court to resolve. And so we are, of course, in front of the court to resolve this issue. This does appear to me to be a case where there was a lack of cooperation. Now, whether the lack of cooperation was due to a lack of sophistication or understanding of things, or a failure to dive into the data and actually understand what was there in order to make appropriate arguments, I'm not really sure, because that's not dictated, but it's pretty clear that it was one or both of those things. In terms of the actual dispute, the defendant proposed the following 3 paragraphs to be included in the protocol. So paragraph 1, the parties also acknowledge that, apart from the CSI protocol, each party has an independent obligation to conduct a reasonable search in all company files and to produce non-privileged and responsive documents to pending document requests. Nothing in the CSI protocol relieves either party of the protocol of its obligations to produce information, and this protocol is an aid to locate responsive documents, not a replacement. Second paragraph. Defendant does not agree that plaintiff's search for responsive electronic documents should be limited to the foregoing individuals, paren 6 identified custodians, close paren. The defendant wants the plaintiff to have all of its employees search for responsive documents and insists that its obligation is to search all its files for potentially relevant information to this litigation, as defendant agrees to do. And then the third paragraph that defendant wanted to add is defendant maintains that both parties have an independent obligation to search all files from all employees that could reasonably contain responsive documents to the parties' document search requests. So just listening to that language, you can see that 1, it's pretty overbroad. 2, it really is consistent with, or is just restating the parties' general obligations under the Federal Rules of Civil Procedure. And 3 is very defendant leaning. It's trying to essentially put in an ESA protocol that's going to be signed off on the court, that the plaintiff will search all 100 people and all sources of information. And that is overbroad. So there are also disputes on specific search terms. Now, Doug's article from eDiscovery today does a really good job of doing the analysis on, when modifiers are appropriate in that. So I'm not going to recover that with you today. But what I am going to cover is that it feels like that there was not a lot of digging into the data to determine what search terms really would have been relevant to be able to resolve this kind of issue, because it feels like the parties were trying to come up with search terms that would be super broad to encompass all of the requests for production in this case, instead of trying to come up with search terms that would be responsive to each individual request for production, which is what I advocate, what really makes the most sense from a perspective of making sure you've got all responsive materials. And so it's something that the court addresses, but you're going to see that the court's ruling says, look, guys, I can only do what you put in front of me. It's not my job to go through this data. And the only information we have about the parties working with the data to be able to provide information on these search terms is that they ran at least one hit report that the plaintiff thought made an overbroad search request, and so therefore asked for a modifier associated with it. But there's not a lot of other information about what the parties were looking at on search terms to be able to help the court understand what would be appropriate. And so what we have is we're before the court on a search term dispute without a lot of information to help the court determine what would really be appropriate search terms here. The other issue is the custodian issue, right? I mean, I've already mentioned this. The plaintiffs identified 6 custodians that were likely to have relevant information after their investigation. The defendants wanted all 100 employees of the bank to have their data searched. Now, we know right out of the gate that asking for 100 custodians in a case between these two parties is going to be tremendously overbroad. We rarely see 100 custodians, except for perhaps in the largest of class actions associated with design and development of products or drugs that would implicate multiple departments and have a need for such a large number of custodians. In this type of case, that is going to be a very unusual request and one that we're going to see the court does not grant. All right, so what's the court's analysis here? Well, the court starts with an analysis of the parties' obligations under the Federal Rules of Civil Procedure. And this is where Judge Parker really lays out some great case law that I would encourage you to take a look at. This is a really short opinion, one it'll take you just a few minutes to get through, but that you're going to want to highlight and keep as key cases related to ESI protocols. So Judge Parker starts out, by talking about that Federal Rules of Civil Procedure 26 and Rule 34 both require the parties to conduct a reasonable search for documents that are relevant to their claims and defenses, and that under Rule 26A1, the parties have an affirmative obligation to search for documents that they may use to support their claims and defenses unless the use would solely be for impeachment. Rule 26A also requires a party to provide such copies of documents or identify them by category and location without waiting for a discovery request. And the court cites to the committee notes from Rule 26 to quote, "The duty to make a reasonable inquiry is satisfied if the investigation undertaken by the attorney and the conclusions drawn therefrom are reasonable under the circumstances. It is an objective standard similar to the one imposed by Rule 11. Ultimately, what is reasonable is a matter for the court to decide on the totality of the circumstances," close quote. So that's really the lay of the land. The court also then cites to Rule 26G, which we've talked about multiple times on Case of the Week, which requires that the responses to the documents be signed, certifying by the attorney that the disclosures made are complete and correct as of the time of the disclosure after a reasonable search. So the court really says, look, based on these rules, we already know what your obligations are. We don't need additional language in the ESI protocol between these parties to codify that language, and nothing should be increasing the breadth of those obligations as they're defined by the Federal Rules of Civil Procedure. So the court really looks at addressing the parties' obligations under those rules and says that there's nothing in those rules that says that the producing party must search custodians and locations that it identifies on its own as sources for relevant information as part of its obligations under Rule 26 and 34. I mean, essentially we're saying that we're noting that we already have those obligations, so we don't have to reiterate them for purposes of the ESI protocol. The court notes that parties, in addition to their obligations under the Federal Rules of Civil Procedure, should also cooperate with the other side to the extent that the other side believes there should be additional search terms, custodians or locations that may have appropriate information, that cooperation should happen, and that is also within the parties' obligations under the federal rules. One of the key quotes from the court on really the need for and basis for and role of the ESI protocol is key here. And that quote reads as follows: "An ESI protocol and search terms work in tandem with the parties' obligations under the federal rules and do not replace a party's independent obligation to produce electronic or paper documents that are reasonably accessible, relevant, and responsive within the meaning of Rule 34, close quote. So, essentially what we're saying here is that you've got obligations under Rule 26, those obligations, and Rule 34, those obligations mean you've got to conduct your own search. It's not up to the defendant here to provide search terms for the plaintiff to go and look at. The plaintiff has an independent obligation to provide that information. If the other side proposes search terms, it is also incumbent upon the producing party to take those search terms into account and negotiate or cooperate with the other side after looking at data as to whether or not the search terms are appropriate or how they can be modified to provide appropriate responsive documents as the party's obligations entitle them to. So the court goes on here to talk about that the proposed language from the defendants was really unnecessary given the discovery rules that require each party to sign its disclosures and certify that they've conducted a reasonable search. And the court noted that to the extent that the language proposed by the defendants here suggests that a party have to search all the company files or all files from all employees, that language is overbroad. And that's really going to be one of our key takeaways here. So focus on that. The court found that counsel for both the parties should consult with their respective clients to understand which custodians and locations are likely to have relevant information, and whether or not it would be responsive, that information would be responsive to document requests. So again, it really feels like we're trying to argue big picture here without getting down to the nitty-gritty details. And we'll talk about that in the takeaways. After the parties engage with their clients, the court states that the parties can then determine the contours of a reasonable search, which may mean eliminating custodians or locations that may have redundant information, be inaccessible, or have any date-related filters that could be called based on the allegations of the complaint. One of the big factors in the court's analysis here is really the disparity between the parties, right? The court notes that when a party is a single person or a closely held company with a handful of employees, the custodians and sources of information may be obvious, and there may not be redundancies in the sources of information. But when a party is a large entity, like the plaintiff here, it is more likely that there will be redundancies in the sources of ESI and custodians or locations where information is likely to be stored, meaning that the more employees you have, the more likely multiple people are going to be copied on emails. So for example, if there are 5 people on an email, grabbing that email from one custodian versus all 5 is going to be sufficient for purposes of providing that information. Unless one of the other 5, uses another subsequent string that would be relevant, which you'll be able to determine once you start looking at that information and determining scope. So again, it's really about looking at the data. You've got to dig into the data and really understand it in order to be able to negotiate effectively. And that comes before you do an ESI protocol. You really need to be looking at your data before you're engaging with the ESI protocol. Now, based on that disparity between the parties here, the court basically says you can't just blanket say that a company with 100 employees should look at all 100 custodians. That's overbroad. Okay, let's move. So we talked a little bit about the parties' responsibilities in discovery and the language that was proposed there. We talked a little bit about the custodians. Let's talk now about the search terms. So the parties here disagreed on the search terms, and Judge Parker goes into the law and really talks about the fact that the court has, quote, broad discretion to manage the discovery process, including determinations regarding which search terms a party should apply, close quote. And she also says, and this is perhaps the most important part of today, search terms, while helpful, must be carefully crafted. And I'll tell you from looking at the search terms here that the parties are discussing, they were not carefully crafted in this case. It doesn't look like there was much review of data in analyzing these search terms. Again, just one hit report run, and that's it. There's really very little information before the court on these search terms. There's the search term and then some proposed modifiers in order to narrow those search terms, and that's it. As the court notes, poorly crafted terms can return thousands of irrelevant documents and increase the burden of locating relevant and responsive ESI. It can also mean that parties can miss documents containing a word that has the same meaning or that's misspelled if you're not looking at the data. So again, you've got to look at the data to determine search terms. Just making them up based on what it is you think you might know about the case is not going to get you the relevant responsive information that you want. The court also notes that broad general search terms, such as the ones the parties are using here, are typically not sufficiently targeted to find relevant documents. Modifiers are often needed to hone in on truly relevant documents. However, what is appropriate in terms of a modifier is left to specialists who can interpret hit reports or look at the data and suggest refinements. That is not an area for the court to do. However, because here the parties can't agree, it's left to the court to do that with very little information that is before it. The court then spends some time going through each one of the search terms and the modifiers associated with them, and make some orders based on what it will require the parties to accept based on a modifier. Even with the modifiers, it seems unlikely to me that you're going to get a lot of relevant documents for these search terms because they're just not well crafted. In terms of how the court comes out, essentially the court looks at each of the individual search terms, decides whether or not the modifier should be accepted, and rules on each of those, and then orders the parties to submit a revised ESI protocol based on the court's rulings. So what we've essentially found here is that the parties have lost the ability to continue to iterate on search terms because they're asking for these specific search terms and modifiers to be a part of the ESI protocol. And so in order to go outside of that protocol and ask for additional terms, they're going to have to modify that order. Instead, what I would propose to you is a better way to deal with search terms would be to iterate on the search terms back and forth based on the individual request for production. Now, that does not mean that the producing party's obligations aren't broader than those individual requests for production, but it does mean that you would have search terms that would be tailored to each of those requests. And they're going to be very different than what the search terms are that are proposed here in this case. They're going to be more narrowly focused. They're going to be actually based on a review of the data, and they're going to be more effective for both sides. They're going to mean that the producing party doesn't have to spend as much time and money producing documents, and they're going to mean that the requesting party actually gets the information that is appropriate for them. Okay, so that's one of our takeaways on the case. What are the other takeaways? Well, if you've had too many conversations with me or you've attended any of the sessions that I've held, whether it's at UF eDiscovery conference or at other conferences over the years, you know that I'm a huge proponent of ESI protocols, but that the scope of the protocol needs to be specific enough to elucidate what the parties are going to engage in and how information is going to be provided, but also broad enough that you're not putting anybody in a box, because you need to be able to iterate on the discovery process. We can have 100 requests for production, and 2 of them can be specifically about a particular database. And the information about that particular database is something that it's unlikely to be addressed in an ESI protocol. You just don't want that level of specificity in an ESI protocol. That's an order that you subsequently have to go to the court to modify. You want to have that cooperation, that discussion with the other side about these individual data sources without having to codify that in an ESI protocol. Next takeaway, when you submit issues on search terms to the court, you need to provide a lot more information than what is available to the court here. I don't feel like taking away even what the court ordered here is really going to help the parties get to the information that they need for purposes of discovery here. And so you've got to think about, is what we're doing really going to benefit us, both from a perspective of defending it on a motion, but also, are we going to get what we want if the court grants the other side's proposal? So you got to provide more information than just one hit report here. And again, get into the data, dig into the data, and actually find search terms that are going to be relevant. Here, you could have had more iterations on discovery to go back and forth, and that would be what's more appropriate rather than codifying the broad language and these individual search terms in an ESI protocol. Next takeaway is really to lose the language that's reiterating what the parties' obligations are under the Federal Rules of Civil Procedure or the state equivalent, unless you're in front of a judge that requires that sort of knowledge to be included in an ESI protocol. A lot of times we'll find that in state court. Sometimes that can be more useful, but in federal court, the judges are well aware of what the parties' discovery obligations are under the Federal Rules of Procedure, and that language is not necessary to include in an ESI protocol. Final takeaway, be reasonable Reasonableness is always our starting point and our ending point in terms of discovery. What you search for, how many custodians you're looking at is, it's always about reasonableness and proportionality. Proportionality really goes hand in hand with what's reasonable. And there's no discussion of proportionality in this case, but really, the notion of asking for 100 custodians is not proportional to the needs of this particular case, where you're talking about an infringement among a 100-person bank and a 2-person real estate firm. So you've got to understand what is reasonable and make sure that you're taking reasonable positions in front of the court. Otherwise, you're going to undermine anything that you come to the court with. When you've taken unreasonable positions in the past, the court will have that in their head when they're looking at additional arguments that you make in the future. Okay, that's our case of the week for this week. Thank you so much for joining me. We'll be back again next week with another decision from our eDiscovery Assistant database. As always, if you are an 𝐒.𝐃.𝐍 member and interested in using eDiscovery Assistant, there's a discount available to current 𝐒.𝐃.𝐍 members and a trial for folks that are taking the 𝐒.𝐃.𝐍 exam. You can access both of those through your 𝐒.𝐃.𝐍 portal. There's information there on how to get that discount or free trial. If you're interested in doing a free trial of the case law and resource database and are not an 𝐒.𝐃.𝐍 member, you can simply go to eDiscoveryAssistant.com and sign up for a free trial. Or you can reach out to us at support@eDiscoveryAssistant.com if you'd like to have a demo for your specific team. We also hold weekly demos at 9:30 Mountain Time, 11:30 Eastern Time on Thursday mornings each week, and you can sign up for those on our website at eDiscoveryAssistant.com. Thanks so much. Stay safe and healthy out there, and I'll see you next week.